Well, let's get you an update on the big development in the Gyanvapi case today. The Allahabad High Court has pronounced its verdict and there is no stay on puja inside Vyas ji ka Tehkhana, permission for which was first given by the district court in Varanasi, after which the Masjid Side had approached the Supreme Court. They were asked to approach the Allahabad High Court, and today the verdict is out. In fact, the Allahabad High Court also has said that the challenge or the plea of the Masjid Side in this case has been dismissed. So, puja will continue in Vyas ji ka Tehkhana. As far as the operative portion is concerned, we're waiting for a detailed order, but as of now, there is no bar, no stay on puja in Vyas ji ka Tehkhana. The appeal of Anjuman Intizamiya has been dismissed.
We are joined by Advocate Vishnu Jain, who led the charge for the Hindu side. Mr. Jain, how important is this victory?
And this is not, I don't see it as a victory or a loss. It's a legal proceeding which has happened in the court. The Anjuman Intizamiya had challenged two orders of 17th of January and 31st of January, appointing of receiver and also the starting of puja in the Gyanvapi complex. Today, the Honorable Allahabad High Court, after detailed hearing, after hearing both the sides, has dismissed their petition. So the effect of this order is that the puja will continue. And if they come to the Supreme Court, we'll file our caveat before the Supreme Court.
So will you be shortly filing a caveat in Supreme Court?
Yes, we'll be.
भगवान की शरण में इसलिए आए हैं कि जो व्यास जी के तहखाने में जो है जो पूजा पाठ अविरल जारी है वह जारी रहे। आज हाई कोर्ट में जो न्यायमूर्ति माननीय राजीव रंजन अग्रवाल जी का जो फैसला आने वाला है, हम हिंदुओं के पक्ष में आए, हम पूरे देश के सनातन धर्मियों के पक्ष में आए, इसीलिए हम बाबा के शरणों में आए, उनसे निवेदन कर रहे हैं। सभी वादी महिलाएं हैं।
इलाहाबाद हाईकोर्ट ने आज ऑपरेटिव पोर्शन ऑर्डर का अपना पढ़ा। अभी पूरा ऑर्डर अपलोड हो जाएगा तब हम बता पाएंगे। ऑर्डर काफी बड़ा है। ऑपरेटिव पोर्शन में ये कहा है कि हमको मुस्लिम साइड की जो दलीलें दी गई वो बलहीन लगती हैं, और जो ऑर्डर डिस्ट्रिक्ट जज का है, डिस्ट्रिक्ट मजिस्ट्रेट को रिसीवर अपॉइंट करने का, और जो पूजा चल रही वो ये चलती रहेगी, और उनकी फर्स्ट अपील फॉर्म ऑर्डर को खारिज कर दिया। हाँ, 227 और FAF दोनों। जी पूजा जारी रहेगी। मुस्लिम पक्ष प्लेसेस ऑफ वर्शिप एक्ट, और उन्होंने ये कहा कि वक्फ एक्ट, प्लेसेस ऑफ वर्शिप एक्ट, और जो टेक्निकलिटीज कुछ थी उसमें कि जैसे अपॉइंटमेंट जो ये किया गया है वो बहुत जल्दी किया गया है, इस सब प्रकार के उनके कुछ आर्ग्यूमेंट्स थे जिसको कि उन्होंने बलहीन पाया।
All right, so no merit in Masjid Side appeal. That's what the court has said, and we're waiting for a detailed order. What we're given to understand is that right after the order was pronounced, security has been beefed up outside the Gyanvapi Mosque, and we have Akanksha getting us more details on that. Akanksha, what is the situation on ground as far as the legal development is concerned? It is being seen as another development in favor of the Mandir side.
Well, absolutely. I'm at the road that goes to Gyanvapi Mosque, and let me firstly show you the situation on the ground. Right after the judgment was pronounced, the security has been beefed up and barricades have been put up. Media has been asked to stand here, not go to that particular area, in order to ensure that the situation does not go out of hand. But the point here is that the judgment, the detailed judgment is out, wherein the Allahabad High Court dismissed the petition that was filed by Muslim side challenging the puja that was being conducted from the last 26 days. In fact, no stay on puja at all. In the concluding remarks, what the Allahabad High Court has said that considering the overall submission advanced by the respective counsel of the parties, I find that not made or any case for interfering in the order dated 17th January and 31st January, appointing the district magistrate Varanasi as receiver and arranging to carry out worship and ritual in the cellar under the supervision of the priest so appointed. Moreover, worship has already started in the cellar since Feb 1st, 2024. So, in a way, what the court has said that it does not find it is not going to interfere in the order that was passed by the district court on 17th and also on 31st of January. To get better sense of what the order is, let me go across to Saurabh Tiwari. क्या कुछ order, क्या कुछ judgment में लिखा गया है?
देखिए, टोटल 165 पैरा में 54 पेजेस में जजमेंट आया है, और मैं 164 पैरा जो बहुत इंपॉर्टेंट है मैं पढ़ के बता देता हूँ। ऑनरेबल हाई कोर्ट का ऑब्जर्वेशन है कि कंसिडरिंग द ओवरऑल सबमिशंस एडवांस्ड बाय द रिस्पेक्टिव काउंसिल फॉर द पार्टीज एंड आफ्टर एनालाइजिंग द मटेरियल ऑन रिकॉर्ड, आई फाइंड दैट द अपीलेंट हैज नॉट मेड out any case for interfering in the order dated 17/1/24 and 31st January, appointing the district magistrate Varanasi as receiver and arranging to carry out worship and rituals in Vyas Tehkhana cellar under his supervision by the priest. So appointed. Moreover, worship has already started in the cellar since.
So basically, High Court का ये कहना है कि वो इंटरफेयर नहीं करेंगे 17 जनवरी के ऑर्डर में और 31 जनवरी 17 जनवरी का क्या ऑर्डर है, क्या कुछ था?
देखिए 17 जनवरी का वो डीएम डिस्ट्रिक्ट मजिस्ट्रेट वाराणसी को जो है रिसीवर जो है अपॉइंट किया गया था और फर्दर 31 जनवरी के ऑर्डर में जो है डिस्ट्रिक्ट जो ट्रस्ट मंदिर ट्रस्ट की तरफ से और जो शैलेंद्र पाठक व्यास जो इसमें है एप्लीकेंट उनकी तरफ से एक प्रिस्ट अपॉइंट करके और यहाँ पूजा की बात की गई थी ऑर्डर में 31 जनवरी के। और फाइनली ऑनरेबल हाई कोर्ट ने कहा है कि जो मस्जिद कमेटी है अपीलेंट हैं दे हैव नॉट मेड आउट अ केस और इन्होंने जो हिंदू पक्ष की हमारी बहुत बड़ी जीत है एंड पूजा विल कंटिन्यू इन द तहखाना।
So this is a big victory for the Hindu side. What the court has stated in the order that
yes, Akanksha, breaking input coming in. We're given to understand that the detailed order is out now. We are being told that as far as the highlights are concerned, yes, the appeal of the Masjid Side has been dismissed, which means there is no bar or no stay on the puja, which was first allowed by the District Court of Varanasi, that puja at Vyas Ji ka Tehkhana will continue. Akanksha, so the detailed order is out now. Akanksha, can you hear us?
Yes, definitely. The detailed order is out, and in fact, it's a 54-long page, quite a detailed order that has been passed by the Allahabad High Court. And the last point that has been mentioned here, which is the 164th point, and the court has mentioned that it will not interfere with the order dated January 2nd. Now, on January 2nd, the district court here had appointed a receiver, in fact, district magistrate as a receiver, and also it will not interfere with the order dated 31st of January when it allowed the puja. So, in a way, clearly, Allahabad High Court stating that it will not interfere with these two orders, and also, in the end, also mentioning that worship has already started in the cellar since February 1st, 2024. In conclusion, what the court has written, that I find that both the appeal filed under CPC fails, which questioned the order dated 17th January and 31st January passed by the District Judge Varanasi on the application appointing District Magistrate Varanasi as receiver of the cellar and arranging for worship and performance of ritual nominated by the plaintiff. So this is, and both the appeals are finally dismissed. However, no order as to cause. So in the end, on 166 point, what the Allahabad High Court has said.
Akanksha, stay on with us. We've accessed the order copy. Sagarika is going to break down the details for us. Yes, Sagarika.
Okay, so Swati, we've accessed the order copy, and like Akanksha was just mentioning, it's a 54-page order copy where the teams here are going through it, but we found some operative parts of this order copy which we must bring to our viewers. On page number 41, para number 111, what does the court say? The appointment of the receiver in no way affects the right or title of any of the party during pendency of the suit, as receiver is appointed to protect the property, being a representative of the court and of all the parties interested in the litigation. He, being the officer or representative of the court, is subject to the orders of the court, and his possession is the possession of the court. So this is one point made by the court. The other part, point number 112, in page number 41, failure of the appellant to establish prima facie possession over the disputed property. Very important point here. Failure of the appellant to establish prima facie possession over the disputed property, and plaintiff succeeding in building up a strong prima facie case, negating the stand of the appellant, leads to undeniable situation that stopping worship and performance of rituals by the devotees in the cellar would be against their interest. So the court here clearly saying that there is an undeniable situation that stopping the worship and performance of the rituals by the devotees in the cellar would be against the interest of the devotees. And why does it say so? Because the court goes on to say that the appellant has prima facie failed to establish possession over the disputed property. Now let's also take you to point number 113 in page number 41. Prima facie, I find that the act of the state government since 1993 restraining the Vyas family from performing religious worship and rituals and also by the devotees was was a continuous wrong being perpetuated. So point number 113 in page number 41 becomes very, very important, where the court goes on to say that prima facie I find that the act of the state government since the year 1993, it was during the Mulayam Singh's administration when there was barricading around Vyas ji ka Tehkhana, even when prayers were ongoing. In the year 1993 it had started. 31 years later, devotees got the permission to go back to Vyas ji ka Tehkhana and offer prayers. Now what does the court say? Prima facie I find that the act of the state government since 1993 restraining Vyas family from performing religious worship and rituals and also by the devotees was a continuous wrong being perpetuated. We'll take you through more aspects of the court order, but here are some operative portions.